Hello everyone, my name is Amber Markin and today I'm going to be educating you on how to prepare a witness for testifying. And I'm actually going to go a little bit deeper and give someone who is testifying a little bit insight into what they will experience and what they will see around them. So not only is this going to educate another classmate to be able to prepare a witness for testifying, this is also a presentation that they could use to show to someone that they are testifying, show to someone who may be testifying in order to give them some encouragement and some information and some insight. So to begin our presentation, we're going to go through a quick agenda, and this is just going to break down all the major topics that we are going to discuss and what we're going to do throughout the presentation. So first, we're going to talk about the process before testifying. Then we're going to go into the courtroom setup and what that courtroom would look like. And then we have 10 tips for testimony. We have ways of reducing stress before testimony. We have a timeline so that the one person who is testifying can kind of get an idea of what that looks like. We have do's and don'ts for a person testifying. And then we have a summary that just wraps up everything and gives some confidence to our testifier. Now we are going to discuss some of the things that will happen before the testifying begins and go over some of the rules related to testifying so that you can portray that to your testifier in an educated manner. So Rule 603 is the oath or affirmation to testify truthfully, and it essentially states that before testifying, a witness must give an oath or affirmation to testify truthfully. And this oath must be in the form designed to impress that duty on the witness's conscience. And now there is some flexibility within this rule because the rule is designed to afford the flexibility required when dealing with religious adults, atheists, conscientious objectors, mental defectives, and children. And that kind of flexibility is related to, as you see on the left-hand side, someone putting their hand on the Bible. They have the flexibility of doing the oath in a different way, in a different manner that isn't reflective of a religious perspective if someone is non-religious and so forth. And then an oath is inclusive of affirmation, and it simply means that the person is to solemnly tell the truth. There's no special verbal formula that's required. They should just simply tell the truth and nothing but the truth. So the foundation of educating about before the testifying is that first and foremost, the testifier, before anything happens, is going to take the oath, and then that you need to educate your testifier that an oath is a promise and it's a legal contract that kind of binds you into telling nothing but the truth. So that's really important that we educate our testifiers and that we understand. Now we have some insight as to who is in the courtroom. So this slide is really going to break down who is in the courtroom and give a little bit of perspective of what the courtroom will look like, but we will go into that in the next slide a little deeper. So who's in the courtroom? We have the judge, we have the prosecutor or the defendant, prosecutor and the defendant, sorry, or we have the plaintiff versus the defendant. And then we have citizens, which are comprised of witnesses and jurors. So the difference between prosecutor versus defendant and plaintiff versus defendant is prosecutor is normally someone who is working for the government or that someone has someone presses charged against them, versus a plaintiff is more in civil cases, and it's someone who is trying to defend a cause. So that just gives us a little bit of insight and a visual perspective of who is in the courtroom. This slide goes into depth about what the possibility of the courtroom setups could look like. In this day and age, with COVID being a thing, and also with possible defendants or people who are on trial being dangerous to others, we have multiple methods of how a courtroom can look like. And so this is important for us to know so that we can educate our testifiers, and also to relate to our testifiers, because it may not be the same in every court case. It might be different, and we want to be educated enough to let them be prepared on what they will encounter when they go in. So on the left-hand side, we see that the witness is available, but there's a white screen behind them, and that is separating them from the spectators. In the middle photograph, we see that the witness is there, but that they are in a completely room, and they are being projected and proctored onto a monitor that is in the courtroom. And then we see the right-hand side, which is normally what will be the most common, where the witness is there, there's the accompanying person, and then there's nothing else blocking them, surrounding them, or protecting them. So this is just really good to know, like I said, so that you can give this insight to your testifier and that they can form a little bit of comfortability about the environment that they're going into. Now we are going to take a deeper look into the courtroom, and we're really going to explain that first picture that we introduced and what the roles are of the people who are within the courtroom setting. So the judge is the public official who is vested to oversee the trial, preside over the selection of the panel, and rule on motions made before or during the trial. So in the picture before, the judge is usually in the center on an elevated chair or podium, and they are basically the big boss, the overseer of everything. And then we had the prosecutor and the defendant, and I decided to go this route because it was a little bit easier to understand. So the prosecutor initiates the prosecution of criminal offenses and presents the case for the prosecution. And then the defendant is the person who has been formally charged with the crime. So the defendant is the person that's been charged with the crime. The prosecutor is the person who is bringing the charges against the person who's done the crime. Then we have witnesses and jurors. Witnesses is a person who saw, who heard, or who has important information regarding the crime. Within this case, when they're preparing someone for testifying, they are the witness. They are going to be the testifier, and they are the person who has that valuable information to the case. Then we have the jurors, and those are people who decide if a person is guilty or not based on the facts of the courtroom. Normally, this is done in a separate room after all the facts have been heard. They go in and they deliberate and they come to a decision and vote on it, and then present that decision back to the court. Then we have bailiffs, and this is law enforcement that keeps order and keeps security in the courtroom, and they also take charge of the jury when the court is not in session. So basically that's just the law enforcement officer that you see in the courtroom. And then finally, we have the court clerk. This is a goodwill ambassador to the public who ensures the efficient operation of court by maintaining records and handling administrative matters. So a lot of time, the court clerk is the one that's sitting there with the recorder device or writing down notes or minutes of the courtroom session, and they are doing all the administrative details of that court case. So this is just a brief, deeper look at the courtroom and who you will see in the courtroom and who the testifier will also see in the courtroom. Now we are going to transition into 10 tips for testifying. And I included this portion into my presentation because I really think that these are things that we should be communicating to our testifier in order to help them do their job within this court case to the best of their abilities. So first, you need to remind them to refresh their memory. Picture the scene, the objects, the area, the distances, and exactly what happened within their head. So then they need to answer questions when estimating time or distance, and when they answer those questions, they need to make sure that they communicate that there is an estimate if that estimate is present. So if they're unsure of the time or it's around 4 o'clock, they need to make sure that it's clear that that's just an estimate. And then they also do not need to agree with the lawyer's estimates unless they independently arrived at that estimate themselves. So you do not agree with the lawyer if they say it's 4 p.m. unless you personally agree that it's 4 p.m. and you come to that decision on your own. Second, you need to speak. They need to speak their words clearly, and they need to speak their own words. So they don't need to try to memorize what they need to say because that comes off as very fake, very rehearsed. They need to be themselves, and they need to go over things that will be questions in their head before the trial, just to kind of refresh their memory on what they might say, and they just need to let the conversation flow naturally. Third, they do not need to discuss the case. So jurors tend to be in the same public areas as the testifier, and so that they can be watching how that testifier acts. Therefore, they should never talk about the case outside of the courtroom because of that reason. And fourth, they need to be a responsible witness. And this means that they need to be serious when they are called forth. They need to hold themselves in a respectful manner, and they need to communicate respectfully and articulate what they are saying in a good way. So just continuing on, our 10 steps for testifying. Our fifth topic is that they need to tell the truth. They need to be readily available and willing to admit every true fact. And they don't need to stop and think what they are going to say about what they are going to say and if that will help or hurt either side, because once again, that kind of throws off the jurors and makes them think that you're not confident in the facts that you're presenting. 6, they need to not exaggerate. So they don't need to make broad statements, and the explanations that they do make need to be in their own words. And they do not need to allow an attorney to put words in their mouth. So if there is confusion or if an attorney is saying something that the testifier does not mean or does not think, they need to make that clear, and they need to make sure that they are not allowing that attorney to put those words into their mouth. 7, they need to listen carefully to avoid confusion. And this includes not getting upset if they feel that they are being doubted. It's the defendant's job to doubt them and to question them. So that feeling is natural, and they don't need to react to that because that looks badly on them. Number 8, do not lose their temper. They always need to be courteous so that they do not come across as emotionally unstable or invalid. Big reactions can cause people to wonder if what they're saying is true, so controlling your temper allows for that to kind of diminish and for you to speak on a level, even toned, and it just falls back into not exaggerating and by speaking respectfully. 9, respond orally to questions. So they need to speak aloud. They do not need to nod their head. The court reporter needs to be able to hear and record their answer. So if it's a yes or no question, they do not nod their head yes or no. They need to speak yes or no plainly out loud. And finally, they do not need to volunteer any information, and they need to correct their mistakes. So they only need to answer the questions that are asked. They do not need to provide their conclusions or their opinions because that's not what they're there for. They are there to provide the facts that they have either seen or heard or were a part of. They don't need to give their conclusions or opinions on who did what because that's not what they're there for. If their answer needs to be corrected or clarified, they need to do that. They need to go back and reiterate what I actually meant was X, Y, and Z. That clarity and that correcting shows the jurors that human mistakes are there and jurors do understand that, but it also shows the jurors that they're willing to fix that mistake, and so there's no confusion in the end. Overall, the 10 tips for testifying, I worded it on the PowerPoint very personally, so that way, like I said, as you are presenting this PowerPoint to somebody else, they can read it and see what they need to do. So just continuing on, our A key to preparing somebody to testify is walking them through reducing the stress related to testifying, because it can be a very stressful situation. A lot of eyes are on them, a lot of things can go wrong if they say something wrong, so it's extremely high stress situation. So I included this tidbit of information that I really enjoyed, and that you can also use to give to your testifier. So, reducing stress before you testify in court, and it just states that sometimes our minds go blank when you think of things that frighten you or make you nervous, or maybe your heart starts to beat really fast, or your legs feel weak, or your palms begin to sweat. And below are the symptoms, or the tips to relieve those symptoms when you're getting ready to testify in court. So these are all things that they might be experiencing, this anxiety related to testifying. And these are ways that you can assist them in reducing their stress before they go into the courtroom. So they can relax their minds. That can be a multitude of things, whether that's closing their eyes and listening to their breath, focusing on breathing, maybe listening to some music or hearing the sound of water falling. That's very person-centered. Whatever they can do to ease their mind and relax it. Breathing deeply is another technique that they can do to reduce stress, and that's just feeling your stomach expand, holding your breath, and releasing it for a few seconds. That slows your heart rate and gets you overall just calm. Stretching, having them stand up or sit up straight in the chair and stretch out, releasing those muscle tensions and allowing them to just relax. Positive self-talk. Encourage them to say, I know that I can do this, or I believe in myself, I got this. Just giving them that affirmation that they are going to be okay and that they can get through this is really going to be a huge factor in reducing their stress. Relaxing your body and relaxing your muscles goes back into stretching. Whatever it takes to get their body to feel calmer will help reduce their stress. And then at the bottom of this, there are just some disclaimers about instruction or shared conditions, and basically it's stating that this is really person-centered, and that it's not always going to be the same for anybody, but reducing stress is a key factor in preparing someone to testify in a courtroom, and so it's our responsibility that we are giving these techniques to our testifier, and that we are walking them through how to calm down before they go into the courtroom. Next, I have provided a timeline for what the testifier will experience, kind of give them an idea of how the day will go in the courtroom. And so this is a great tool to educate your testifier and prepare them, because it gives them insight into what's going to happen. And when you know what's going to happen and you have an idea, then you can be calm and feel better and more confident about doing what you're doing. So first they're going to go in and they're going to sit on the stand near the judge when they are called forth. And this is normally after that they give their oath saying that they will testify and everything that they say will be truth and nothing but the truth. And then one of the lawyers will most likely ask their name, their background information, and why they are there, and what information kind of pertinent to the case makes them good for being a testifier or a witness. Next, the lawyer for the plaintiff or the prosecutor will begin questioning. These questions will be very broad. These will be questions that you've went over most likely with the prosecutor beforehand, and you should have they should have been prepared for this. After that, the lawyer for the defendant will come and they will cross-examine. So this is where they are trying to catch any errors in your testifying, try to catch you lying in the facts, anything like that. This is where you got to be really careful about allowing the attorney to put things into your mouth and allowing them to kind of sway your perspectives. Finally, the plaintiff or the prosecutor lawyer might redirect after the cross-examination just to do some clarifying, and then you're kind of released from the stand until you're needed again, or in general from the case overall. So this just gives a good insight as to what will happen in the courtroom on that day, and hopefully will ease your testifiers' nerves and give them some confidence going in. Finally, to kind of conclude our presentation, we have some do's and don'ts for our testifier. So these are things that you really need to communicate to your testifier to do or don't do when they are testifying in the courtroom. So they do need to dress conservatively. They need to be very business casual, dressed appropriately, nothing showing, nothing too revealing. They also need to allow opposing counsel to finish their question before they answer. Don't interrupt, don't interject, just allow them to finish their question, because you could possibly set them up for failure when they interject because they don't understand the question fully, and then they give a fact or information that's incorrect due to not hearing the question in full. You, as the person, need to prepare your testifier thoroughly. This is going through all the cases and scenarios that may happen, the questions that might come up, do some mock role playing and mock trial, prepare them thoroughly so that they can feel confident going in. Know where they are going to testify and get there early. So they need to be prepared, know the address, the time that they need to be there, and almost tell them to be there about an hour early just in case something happens with traffic or anything like that. That way they get there on time and there's no issues. And then finally, you need to tell them to be respectful toward both the direct and the cross-examiner. So that respectfulness all around just gives confidence to the juror that this person is genuine and that what they are saying is true. So what they don't need to do is they don't need to wear any kind of distracting or bright clothing, heavy makeup, or bright, loud jewelry, because it's just distracting from what they are saying. What they are there for is to speak the facts that they know, and all this stuff can kind of distract from what they're saying and make the juror think that they are not as professional and that their opinion does not matter. Also, don't be late or unprepared. Obviously, we know that being late is really bad, and being unprepared is even worse. We want to make sure that we set them up for success, and we prepare them, and we get them there on time. Don't be cavalier or too casual. This is a very professional setting. They are not there to have a conversation about their day or about what they think is going on. They are there to provide the facts and to be honest. Don't be argumentative, and don't use jargon. So don't use outside language such as slang or anything like that. And don't be argumentative. Don't sit there and argue with your cross-examiner or anything like that. You can clarify, you can correct, and by stating this is what I mean, but they don't need to argue with them because that just reflects poorly on the testifier. Overall, this is just a little sum up of what you should be preparing your testifier to do and don't do. And this is also another tidbit of information that you can print out and give to them just as a reminder. So just to summarize and conclude my presentation, testifying can be extremely intimidating for a testifier, and so it is our job to prepare them and to appropriately make sure that they know what's going on and understand everything, and remind them that the best thing that they can do is to be calm, calm their nerves down, to be themselves, and to be honest. Everything else will kind of fall into place if we remind our testifier to do these things. And so if we're doing these things and we're reminding our testifier to doing these things, we should be preparing them appropriately and they should be ready to sit on the stand and testify. Thank you for watching this and for learning with me and allowing me to educate you on this subject. And I hope that this is a tool that not only educates you, but also that you can use to educate your testifiers in the future. Thank you.